This is our Mohamed Ali Foundation slot in the program. We've had the privilege of hosting Mohamed Ali Foundation fellowships, thanks to His Highness Prince Hilmi and the foundation's support that we've had to bring distinguished scholars to Durham with our Grey College working on early Egyptian, late 19th century, early 20th century histories, small h, but it covers a multitude of sins, anthropological, political economy, cultural, and so on. We have a very competitive system where we poll in the autumn, and then we select with a very distinguished group of advisors that I have, the best applicants who come in. And I'm delighted to report that the best applicants for 2025 are the gentlemen sitting right here in front of you all.
Sign your name.
I'm going to let them brief you on the subjects that they're talking about, rather me giving you the title and not being able to say anything about it. I want their passion to come through. We publish the papers in the Durham Middle East papers, and once the fellowship cycle is finished, we'll actually then publish them as a book, drawing from generous photographs that we have in the Helmi collection in the library. If you have not visited our archives, you are missing a trick. They are extraordinary, so much so that when a senior Saudi prince comes here, he says, I want to see your Mecca and Hajj photographs. And that for us is the greatest badge of honor that we can wear with the archives that we have. We are delighted to have His Highness with us. As always, he's a dedicated supporter of the fellowship, and it's wonderful that our fellows also manage to meet with him during their stay here. Gentlemen, your names are on the wall. I don't need to say anything about it. I know Will is going first, so I hand the floor over to you. Welcome, Will.
Thanks very much, Anush, for your hospitality, and thanks to the Mohamed Ali Foundation and to Prince Abbas Hilmi for having us. Thanks also to Graham for the support that he gave in arranging, and to my hosts at Grey College. I've known of this archive for a long time, but I was unaware that it is all but entirely available online as of recently. It's a miraculous resource for historians of modern Egypt, and it will fuel scholars for decades to come. And I feel very grateful that I've had this time to begin to get to know it. But I've only been here for a little while, and what I'll have to say today is preliminary, based on a week and a half beginning to work with these records. I've been looking at legal questions surrounding the sequestration and liquidation of Abbas Hilmi's property in Egypt during and after the First World War. And I want to share some of these early findings with you. So in the Palace Green Library, though not in the online archive, is HIL +107, which is a lavish printed volume containing the memoranda submitted by Abbas's lawyers to the Anglo-Turkish Mixed Arbitration Tribunal in 1926 and 1927. This volume was printed in Paris on heavy, expensive paper, presumably in only a few copies. This may be the unique copy available at the Palace Green Library. In today's talk, I want to say a few things about this object, who wrote it, the arguments it contains, its antecedents, and its aftermath. Now, the basic facts of the sequestration episode are reasonably straightforward. In December 1914, shortly after the onset of the First World War, the British authorities, who had occupied Egypt for more than 3 decades, extinguished Ottoman sovereignty over the province and deposed the khedive Abbas Hilmi in favor of his uncle. The reasons for the British move against Abbas were multiple, and the details need not detain us here, But the crucial point is that Abbas was classified an enemy under martial law. As a result, his property was subject to sequester and placed in the hands, in the management of a public custodian. 5.5 years later, in 1920, this property was liquidated, and Abbas was compensated with 589,865 Egyptian pounds. Believing that this was not a fair price, he pursued legal remedies at various venues, most notably and strenuously at the Anglo-Turkish Mixed Arbitral Tribunal. And these are the briefs for his arguments at that tribunal that are reprinted in the luxurious volume I referred to. In 1927, 2 years after Abbas made his initial claim, this effort failed as the tribunal declared itself incompetent to adjudicate the case. It was only in 1931 that Abbas reached a settlement, a negotiated settlement, not a litigated settlement, with the Egyptian government, in which he terminated his claim and recognized King Fuad in return for an annual allowance of 30,000 Egyptian pounds. The declaration of war on or by the Ottoman Empire must have brought certain relief to those British officials charged with describing and justifying Britain's position in Egypt. An inherited set of structures, long superseded in all but the letter of the law, could now be set aside. Ottoman sovereignty required continued consultation and negotiation with Istanbul, payment of Ottoman tribute, observation of the capitulations, and a bunch of other legacy laws, a long list of difficulties. The beginning of this war allowed these structures to be replaced with new ambiguities, such as Egypt's so-called independence of 1922 and its 4 reserve points. But in 1914, martial law meant lowering the veil that had protected Khedive Abbas's often challenging independent position vis-a-vis British domination in Egypt. Now that Egypt was no longer Ottoman, there was no longer a khedive. Abbas Hilmi became persona non grata, and his properties, his da'ira khasa, became enemy property. Now, enemy property was a well-understood category in the new field of international law. This category allowed the administration to circumvent lingering and unresolved problems of crown property in Egypt. And these problems of crown property had their own history, a history which stretches back almost 100 years before 1914. Now, this history of da'ira khasa, da'ira saniya, crown property in Egypt, has not yet been thoroughly written, and the records in the Abbas Hilmi papers are an outstanding source on this topic, and some enterprising scholar, not me, will write one or more histories of this crown property. But just to say a few more words about this da'ira, which is the crown properties in Egypt. Since the time of Muhammad Ali Pasha, the line between state property and the private property of the monarch had been quite indistinct. Muhammad Ali's power derived from his conclusive capture of all of the resources of the province of Egypt, and his successors aimed to maintain a version of that possession by virtue of rule. As is well known, Ismail Pasha, who was the leader of Egypt in the third quarter of the 19th century, his bankruptcy in the mid-1870s spelled the end of the capacious royal daira. However, the impulse to rebuild and expand royal estates endured, and Abbas Hilmi showed particular creativity and determination in this regard. The properties sequestered in 1914, his da'ira khasa, differed considerably in size and character of those of his forebears. I haven't yet managed to work out with precision sort of the size of this da'ira khasa, but the archives contain many details of its management. What we're talking about, it seems, is about 20,000 fedans or acres of rural property, as well as some urban estates, the Montaza palaces. The da'ira khasa of Abbas Hilmi was less than 5% the size of Ismail's da'ira of a half century earlier, which approached 500,000 fedans. But his daira, like that of Ismail, was a diversified portfolio of rural and urban property as well as investments. It was also collateral for considerable debts. He held shares in a bunch of companies. Crucially, the status of this khedivial property remained different from other property in Egypt, such as the large estates of the rural landholding class. Just as we're witnessing in the United States at this moment, where I live, wealthy monarchs can easily divert state support towards their private property interests. And this was, Egypt was no exception. Now, there was a set of courts in Egypt called the mixed tribunals, and these are at the center of the larger project that I'm working on. And I'm arguing that these mixed tribunals that appeared in the 1870s are the earliest substantial international court of the modern era. And they were established in the 1870s in order to address this precise problem. The sovereign of Egypt, Ismail Pasha, was using his power to protect his private property and the Egyptian state's property in ways that, to the empires of European finance, broke the rules. And so these mixed tribunals were meant to enforce these rules. They were a compromise between European powers, and they applied these rules to the Daira Siniya, the Daira Khasa, the crown property of the khedive. So the mixed tribunals and the Daira Khasa were intimately bound up with each other from the very start. And indeed, the first major ruling of the court, the Capri case, reiterated the court's jurisdiction over the khedive's property. So this was an ongoing question throughout this time period. And this question returned many times, even in the decade before 1914, and there was sort of a continuous set of litigation around who got to control and have a say over the khedive's property. So my point is, this was an ongoing problem for Britain in particular as an occupier of Egypt. How are they to take control of this property, to get control of this property? Abbas managed to maintain strong independence despite the best efforts of Cromer and his administration. There are a couple of sidelines to this property story which warrant investigation, which I haven't yet been able to work out and may not during my time here, but this is another area where these archives are rich and offer a lot of promise. First of all, a large part of the Daira Khasa, as I mentioned, consisted in shares in several property investment companies, which were heavily leveraged and sort of dubious investments. And there's a story here that other scholars have written and are continuing to write. Abbas's claims that I'm discussing here focus on real property, but his legal work was more complex and involved these shares and investments. And there's a second story too about this property, which is that while he was in Constantinople in 1914, just before he was deposed in the month of December, and just before his property was sequestered, Abbas converted his whole Daira Khasa, his whole crown properties, into a waqf. I haven't yet been able to learn about this particular legal tactic, but I think this is an interesting question to explore. Now, the Daira had transformed many times between its establishment under Muhammad Ali and its sequester in 1914. Legally, it can be considered, as I've mentioned, a sort of crown property, but also it could be considered like a civil list or a privy purse. It played a bunch of functions. And it was really hard to pin down what it was doing. So enemy property, this category of enemy property, which was suddenly available in 1914, was a wonderful legal solution. It meant that military officials could simply take control of this property, assign a public custodian to manage it, collect the revenues and hold them in escrow. The public custodian appeared regularly before the mixed tribunals to manage ongoing litigation about these properties. And he prepared detailed annual reports, which the archive holds for 1915, 16, 17, and 18. In 1920, the military administration moved to liquidate these properties. Now, I've not been able to work out all the details of this sale, for instance, who purchased the parts of this daira, but it appears that they were sold at steeply discounted prices. And as I mentioned earlier, Abbas was paid just under 600,000 Egyptian pounds out of the proceeds of this liquidation. Now, he was unhappy with this sum, as I mentioned, and he and his lawyers explored 3 legal avenues to express their unhappiness with the compensation. Yes. Now, the first of these avenues was the mixed tribunals and other Egyptian venues, so attempting to win compensation using Egyptian courts. The second was using British courts, and the third was the mixed arbitral tribunal. I want to talk about this litigation, touch on some points of it in the rest of the time that I have. I'm trying to finish a book about Egypt's role in the general field of international law in the later 19th century and the early 20th century. And I'm arguing that Egypt's unusual sovereignty regime made it a globally significant site of institutional experimentation and legal career building. And the mixed tribunals that I've mentioned a few times were at the center of this innovation, the first major international court of modern times. And they ought to have been a wonderful place for Abbas to settle his dispute over his daira. They had constantly been considering cases of the daira, and one of the first things that they said was, "We have jurisdiction over. We are competent to decide cases about crown property." So it would seem logical that this would be the place to argue it. But from very early on, under martial law and indeed in the post-war administration, the Egyptian government moved to produce laws which excluded Abbas Hilmi, specifically by name, from pursuing any litigation over the sequester. So in 1922, Law 28 of 1922 confirmed the liquidation of Abbas Hilmi's property and said that no judiciary action on this act could be heard at any Egyptian venue. A year later, in 1923, in the Constitution of 1923, Article 126 reiterated this point and gave it constitutional force. There would be no relitigating this question in Egypt. And in the same year, Egypt passed a bill of indemnity, and this was as a condition of ending martial law under the British. And this bill of indemnity forbid any action before Egyptian tribunals about anything that the military had done under martial law, including, explicitly they stated, with respect to the properties of Abbas. So legislation made it impossible for him to pursue this question before any Egyptian venues. So he turned then to the courts of Great Britain and filed a petition of right. This petition was also rebuffed quite quickly. Britain said they aren't going to consider this at all. Now, Abbas Hilmi had a network of agents and advocates throughout the world, and the archive is replete with correspondence with them, trying to figure out what to do. And it seems that they were this network of professionals were able to find vast patronage out of Abbas Hilmi. Some of them definitely took advantage of him, and there's a notorious case of an Italian lawyer in Egypt called Di Martino, who was engaging in all sorts of fraud in his management of Abbas Hilmi's property. This is a sideshow of managing this vast estate at a distance, but looking at the actors, at the workers that he hired and contracted is part of what is interesting to me, and I want to talk about them a little bit more now as I talk about what happened towards the mixed arbitral tribunals. So this was the third place that he looked, and this was another experimental, innovative legal venue. These tribunals were established in the wake of the First World War. They've been a subject of recent scholarly interest. There's a 2023 edited collection on the mixed arbitral tribunals. The Treaty of Lausanne, there were tribunals for Germany. I mean, they came out of the Versailles Treaty. There were tribunals for Austria-Hungary, but the Lausanne Treaty, which sort of resettled the war with the Ottomans, established 6 of them. There was an English, a Belgian, a French, a Greek, an Italian, and a Romanian tribunal dealing with settling problems arising from the end of the war, particularly property disputes. The Greek-Turkish tribunal, we know, heard almost 12,000 cases. And it's not clear to me how many Egyptian cases were heard by this tribunal. Certainly there would have been many cases that could or ought to have been heard, but this is definitely a gray area of jurisdiction, which Abbas's arbitration explored quite extravagantly. And this is one of the interesting points which I hope to work out the details of in the weeks to come. Yes, sorry, here's the litigation paths. But one thing which is clear, the details of the argument I only have an impression of and need to have much more solid. But one thing that is clear is that in all of this litigation, somebody has to pay for it. There is, and this is sort of a materialist view of the law that I want to insist on in the work that I'm doing in this broader project. So in this case, who is paying for this jurisprudence? Well, that's Abbas Hilmi. Who's getting paid for this jurisprudence? He assembled a team of experts in support of his case. And Ardern Holm Beeman, who is a journalist who wrote a book called The Dethronement of the Khedive, and I've worked on this fellow as a source a little bit, and I use him with a grain of salt. But I'll say that he estimates that that the estate, that the Abbas Hilmi spent between 50,000 and 80,000 pounds on litigators in this dispute before the mixed arbitral tribunal. So if you look at the payment that he received in 1920, or indeed his claim, which was for 2 million pounds from the mixed arbitral tribunal, 50 to 80,000 pounds is perhaps a worthwhile investment, but it's sure a lot of money going into lawyers' fees. So who was he paying with these lawyers? Well, here is his legal team before the mixed arbitral tribunals. Some of these names, some of you might recognize. Certainly the 5 consultants and work from briefs from each of these appear in the archive. These are luminaries of the international legal profession. And I could speak about each of these, but I want to focus on the main lawyers who were arguing this point for him, including in hearings in 1927. Tahir Bey participated in the Lausanne negotiations, and he was a professor at the Faculty of Law in Constantinople, but he was also a member of the Permanent Court of Arbitration of The Hague. And eminently qualified to do this work, and certainly very expensive. The second fellow listed here, Gaston Bergerie, was a lawyer at the Paris Court of Appeals. He was also a radical politician, and in thinking about the role of Egypt in international law in my broader project, one of the things that I'm trying to argue is that work in Egypt furnished crucial professional prestige, but also money, material resources for a vast coterie of lawyers who would go on to make a mark in international law in Europe. And so if we look at a fellow like Gaston Bergerie, who certainly made a couple of years of very substantial income out of this litigation, he went on to do a number of things. He was a radical anti-fascist politician, but then was also the Vichy French ambassador to Ankara. If you think about what underpins the people who occupy these roles and do sort of a genealogy of their material position, this story, I think, involves finding who was paying them, what they were being paid for, and the litigation over this estate is important, plays an important role in this. Okay, I just want to say a couple of arguments about a couple of things about the arguments that they were making before the Mixed Arbitral Tribunal. There were basically 2 points in their argument. One of them is that Abbas Hilmi's nationality qualified him for having his claim settled before this tribunal. This claim depended on Abbas having Turkish nationality, and he had been excluded legally from Egyptian nationality. And so his point was that he had always enjoyed Ottoman nationality because there was no Egyptian nationality until the end of Ottoman sovereignty. And indeed continued to enjoy Turkish nationality because he had no other nationality available to him, therefore was liable to appear before this tribunal. And this was the line of argument which was most interesting to the lawyers and to the consultants. In the decision that the tribunal produced in 1927, they said, we're not paying any attention to these nationality arguments because they found another reason to reject the whole claim and state that the tribunal wasn't competent. And this other reason had to do with the status of Egypt under international law. And this part is, I have to admit that I'm not clear on the nature of these arguments yet. The tribunal had competence over territories which had been detached from the Ottoman Empire and were under enemy occupation, under enemy protection during the First World War. But there's a whole sort of timing question. Did this happen before 1914? Did it happen before 1922 when the agreements were made for Lausanne, which was signed in 1923? How did the timing work? And Egypt was the lawyers were able to finagle stories about timing, which made Egypt appear not to have been under Ottoman jurisdiction at crucial moments. Of course, reading this and thinking about laws of equity, for instance, it makes no sense at all that Egypt was not part of the lands which a tribunal like this could arbitrate. Anyway, you'll have to wait with bated breath for the printed version of this paper where I'll get all the details of the story straight. Anyway, long story short, the tribunal declared itself incompetent to consider the case of Abbas Hilmi, and so these $50,000 to $80,000 pounds were down the toilet, perhaps, because there appeared to be no further venues for him to pursue. But, and this is something which as I say, I've been working with these papers for 6 or 7 days, and this is something I discovered just yesterday. In 1931, he came back with this question, and he did this with some success. This was as I mentioned earlier, a negotiated settlement, not a litigated settlement. And in this settlement, he received, in return, as I mentioned earlier, in return for acknowledging the sovereignty of King Fuad, he received this £30,000 Egyptian pound annuity from the Egyptian government for the 14 remaining years of his life, which adds up to 400,000 pounds, which is in the range of possibilities of his £2 million claim. So maybe the work of these lawyers was not entirely in vain. Obviously, Egypt felt like he had some leverage over them, which they wished to negotiate away. Great Britain also agreed to make a payment in response to the petition of right that he made, and this payment was just under 10,000 British pounds in return for him going away and no longer asking anything of them. And there's correspondence on this issue, and I hope at Q to see how it looked from the side of policymakers. Okay, I want to close now. I have one more paragraph. Close with a brief epilogue. Next to the papers in the Abbas Hilmi archive that I've been talking about, this last set of papers where he dismisses having any claim to the throne in Egypt, is another set of correspondence very much in line with my broader interest in the role that Egypt played in the material advancement of international lawyers. This is a 1932 exchange of letters with the eminent jurist Gilbert Gidel, who was professor of law at the University of Paris. Gidel wrote a memo for Abbas, giving his opinion on whether the 1931 agreement with the Egyptian government placed any restriction on Abbas's political activity outside of Egypt. And at this time, there was chatter about Abbas perhaps taking the throne in Syria. The content of the memo is, to my mind, less important than this passage from the cover letter, in which he thanks him for the generous fees that he received in return for producing this memo. Now, I haven't been able to determine the amount of this honorarium. Of course, on one level, this appears to be an amusing anecdote of international lawyer carpetbagging and exploitation. And I noticed in trying to read about Gilbert that Gilbert in 1935 nominated a certain Benito Mussolini for the Nobel Peace Prize. So obviously he knew how to work connections. But there is a more serious story here, I believe, about the making of international law, in which work of this sort should not be considered marginal or exceptional or trivial, but should be seen as essential to the constitution of the discipline, in spite of the discipline denying it and considering itself a very, very serious objective discipline. It was not international lawyers who gave Abbas's great-great-grandfather Mohamed Ali possession of Egypt. It was those lawyers who, from the 1870s to the 1930s, managed the dispossession of the family such that Britain could settle accounts with Abbas Hilmi for less than £10,000. Thank you very much for your attention, and